Mr. Jacobson, good morning.
Good morning. If it pleases the Court, my name is Miles Jacobson for John Hinds. There are two matters in particular that I'd like to review, and one of them concerns whether the erroneous instructions by the trial judge were at all ameliorated by the rest of the instructions, that is, looking at the instructions as a whole.
Mr. Jacobson, do you know where this instruction came from? Was it from the Superior Court standard instructions? I mean, have you seen it before?
The one on expert testimony.
The instructions most literally came from the Commonwealth who proposed it in that case, but not quite in this form. That is,
From the Commonwealth who proposed it in this case?
in this case. But, and they refer to that fact that they did in their brief. But they did not propose it in the form that the judge gave it in. It does come from a case in which only a Commonwealth expert had testified, Your Honor.
That's what I meant. Okay, so that's where it comes from, and that's why it says the Commonwealth
That's right. That's where that error, in a sense, originates.
Well, while we're talking about where these things might come from, do you happen to know is there any sort of instruction recommended in the model instructions on homicide for expert witness testimony? My memory is that there isn't.
I don't recall, Your Honor. I have.
Well, that's all right if you don't know.
I have in my brief addressed what I believe the court says is should be the correct instruction for this kind of situation. But I don't recall whether it comes from the model instructions or not. In this case, of course, the judge's instructions was clearly an error. What the judge instructed the jury was that they were not allowed to consider the opinion of the expert unless the jury first found.
And there was no objection?
Unless the jury first. Yes, Your Honor.
No objection.
There was no objection after that instruction was given. That's correct. And that is one of the grounds for the appeal. But even barring whether there's an objection or not, when we have a situation which in effect lowers the standard of proof, this court has said that we don't need to reach the question of whether or not there is a substantial likelihood of miscarriage of justice.
What case was that where we said that?
Not in the brief?
It is in the brief, but the case is Commonwealth versus Labriola. It just says errors of a certain magnitude do not need to be reviewed for harmless error.
But it doesn't say this? It doesn't say anything about this particular type of instruction?
No, but this instruction is something like this problem is addressed by United States Supreme Court, United States versus Cool, which is also in the brief. In United States versus Cool, the instruction was, the situation was this. An accomplice got up to testify on behalf of the defendant, and the accomplice said, I did it. The defendant didn't do it. The judge said, you can't consider this evidence unless you find beyond a reasonable doubt that what the accomplice said is true. Then you can consider it. That was clearly a due process violation. And there's not much more to say than that that due process violation required a new trial. So in this case, we need to address whether there was anything else, which the Commonwealth suggests there is in their brief, that there's anything else in the instructions that in fact ameliorate the error here. And there is something that looks facially like it might be, and I would appreciate an opportunity to draw the Court's attention to it. And that is, the Court does say, appropriately, many times, that the Commonwealth bears the burden of proof beyond a reasonable doubt on all the elements. Now, the reason why that doesn't ameliorate this problem is, of course, here we're not talking about an element. We're talking about facts. We're talking about opinion evidence. Can you consider certain facts? Can you consider what this expert has to say if the disputed facts have not been proven beyond a reasonable doubt? And the answer to that by the judge in this case was, no, you can't. So it's perfectly possible for a rational juror to think, all right, the Commonwealth still bears the burden of proof beyond a reasonable doubt on each element, that is, premeditation, malice, etc.
I suppose the correct instruction would be something to the effect of you can accept the expert if you find his facts, assumptions and facts true.
Yes, Judge. Yes, Your Honor.
Well, what is the standard for finding something true?
It's not beyond a reasonable doubt. We have many standards in the legal system.
Yeah, well, what is it then?
You mean, is it by a preponderance of the evidence?
Yeah, what is it?
There's no court that has suggested, certainly this court has never suggested, that the standard is beyond a reasonable doubt, because that's the standard that is reserved.
I know it,
for
but
one-
what do you say the standard is?
But isn't the standard, there's a typical Superior Court instruction about expert testimony, if my memory serves me correctly. It's been a long time ago now since I've given the instruction, but something like you can't consider the opinion of any expert unless you find that all the assumptions on which he or she bases the testimony, that there's evidence to support those assumptions.
Yes, that's a typical.
That's the typical instruction.
That's a typical.
That you say
There's
should have been
evidence
given
to
you.
support it, and I think that's
Right.
the appropriate instruction.
Well, isn't it really that if it's a situation such as this one where you have this was a opinion rendered on a hypothetical, right?
Yes, Judge.
That the jury has to find, it's what Justice Graney is saying, it
think
has to find this true.
I think in this kind of circumstance, Justice Graney is correct that we're talking about what is true, and I cited that in the brief. Not what is proven, either. The word proven is disapproved of, but let's not argue about the word proven, but true. And what Justice Graney is raising is a question that I don't have a good answer to, which is, what's the standard of proving that it's true? And
Evidence to support the assumption isn't much help either, because the doctor's testimony in itself is evidence, perhaps, to support the assumption.
I'm sorry.
Well, I guess I'd like to know if it's preponderance or what it is. I don't know. We'll figure it out. But your point is it's clearly not beyond a reasonable doubt.
Yes, that's my point. And my point is also that when the judge emphasizes in the case that the Commonwealth nonetheless bears the burden of proof on the elements of the offense, that doesn't tend to ameliorate this problem. Because
Mr. Jacobson, I understand that the Commonwealth doesn't really rest its argument on that. The Commonwealth, at least as its first explanation as to why the Commonwealth deals with this as a substantial likelihood. So leaving that question aside, the Commonwealth says that the judge correctly and repeatedly instructed the jurors that they should consider any credible evidence on the defendant's mental state.
Indeed. But then the judge also says, this is in a sense a version of Justice Graney's testimony, if we follow this, or question rather, if we follow that, now here I am a juror, and I'm trying to think, well, what's credible evidence? Well, he gave an opinion, and now the opinion is, let's say, to use a shorthand term, mentally impaired, but it's based on disputed facts. And the judge just told me, I am not allowed to consider disputed facts unless, to use the whole phrase, the Commonwealth has proven beyond a reasonable doubt that those disputed facts are true.
And I guess we need not concern ourselves with, is there any other proof that the jury might have been misled by this, because the opportunity to ask a question they didn't have or didn't need to use, because as I understand it, wasn't a tape of the instructions sent in with them? So if they were befuddled by anything, they could just plug it in and listen to it.
Justice Graney, I should know the answer to that question, and it sounds right to me, but I'm not 100% certain.
I
Thank
think
you.
the record does reflect that it's
Thank
what
you.
you're saying.
Well, I think that's important, because many times cases turn, if there's a little bit of doubt about it, on the fact that the jury came back and asked a question that focused on the problem. Believe me, they can figure it out. They're like laser beams when it comes to certain things.
Well,
but here they had the instructions.
And if they put all together and did a mathematical equation, one of these instructions doesn't cancel the other. That is, they're all perfectly harmonious with one another, all the judge's instructions. By the way, if I may, Chief
Mr.
Justice
Jacobson,
Marshall,
and maybe I'll ask Ms. Lynch this. Do we still have the tape of the jury instructions? Is that in the record, Ms. Lynch? The actual tape, not the transcript?
I would be glad to report that by letter, if I may.
I ask that because sometimes the fact that there's no objection is an indication that at the time it didn't seem like a mistake. And in some way, the way the judge was giving the instructions, and so it might be helpful to listen to the tape if we have the tape.
I can just tell you as a general matter that tapes of instructions are usually identified as a exhibit for identification.
What goes in with the jury, I understand
So it would be
that.
part of the record.
Well, anyway, here we are.
Chief Justice Marshall, I would like to bring your attention to the fact that Commonwealth does claim that this erroneous instruction was ameliorated by the reasonable doubt instructions to the elements, because it appears on page 32 of their brief.
Okay.
But I'd like to go on.
An aside, but why did it take 7 years for this case from the time it was entered here to get argued? I mean, I'm looking at the docket, and it was entered here in May of 2000.
The two longest periods of time.
Switching counsel and all that stuff?
The
Transcripts?
The two longest periods of time that were taken up during this period of time were, I filed a motion for costs at one point. I was contemplating filing a motion for a new trial, and I wanted to have the defendant reevaluated. And I filed a motion for costs. That motion for costs was not acted on for over 15 months. So that takes a part of that period of time. And then...
You mean some judge sat on that for 15 months?
I didn't say that, Your Honor, but that's not an unfair inference.
The motion was pending in the Supreme Judicial Court, correct?
No, Your Honor, it was
downstairs.
referred immediately by this court to the Superior Court.
Oh, I see. I
So
thought
it
you
was-
said the motion hadn't been acted on. It was sent down to the Superior Court and was not
I
acted on
didn't- I
there.
should have spoken more clearly.
Okay.
And another portion of it was taken up with a very lengthy period of time in which we were trying to evaluate, which was complicated, because this man had suffered serious heart problems, had open heart surgery, was taking lots of medications, was going on the medications, was going off the medications, all of which had a potential effect. There were many relatives who gave reports to me about things that needed to be followed up with
Okay.
by the expert. But
So
that's-
except for that 15-month delay, there appears to be extrinsic valid reasons other than court-related reasons why the case didn't progress as fast as it could.
To a significant degree, that's true. I'm not saying that I might not have proceeded myself more quickly at various stages, but those were two very large parts of what really happened.
All right.
The second point I would like to focus on at the moment is how it is that this instruction tended to lessen the Commonwealth's burden of proof, because that makes this particular problem not just an error in the instruction, but a fundamental kind of error. And again, I would refer the court to this case, United States versus Kuhl. In Kuhl, they talk about the fact that when the judge sets up an artificial barrier to the defendant's evidence, that what it does in effect, it lowers the Commonwealth's burden. So in this case, as we know, the defendant had the right to present evidence that all proofs favorable, of course, but also had the right to produce evidence about mental impairment and his mental state. It goes both to malice and to premeditation. He did present such evidence, or he attempted to present such evidence. And that evidence came in, but the value of that evidence was then taken away by this instruction. So, because it set up such a high bar. That's the same bar that Kuhl talks about, which is setting up a standard for the defendant's evidence of beyond a reasonable doubt. It's an improper bar. It tends to interfere with the defendant's ability to have its evidence presented to the jury. And the result of that is that it lowers the Commonwealth, or in the United States case, the United States' burden of proof.
Isn't
A
this
fundamental
just a-
due process error.
I'm sorry, I
Excuse
didn't
me.
mean to interrupt you. Isn't this a little different, though? I mean, is your argument that, in part, that not only that it lowers the burden of proof on the Commonwealth, but by saying that the facts have to be proved by the Commonwealth beyond a reasonable doubt, since the Commonwealth obviously is not seeking to prove under any standard the facts on which you're relying, that it's self-defeating in the beginning?
I am saying that it's self-defeating in the beginning, but Justice Bofford, that's not the heart of the argument. And that's because, to the extent there are some cases which go like this. That argument was so out in left field, the jury is bound to disregard it. Okay. Somebody could say that about what the Commonwealth is trying to prove. Obviously, the Commonwealth is not trying to prove the defendant's case. And so a juror, although a rational juror, I believe, could be confused by this, and that itself would be grounds for reversal because of the likelihood of that confusion. Some jurors might figure it out and think, well, wait a minute here, the Commonwealth really, it's not the Commonwealth.
There was a slip of the tongue.
As to the Commonwealth for the Commonwealth's expert, the defendant for the defendant's expert, but the problem is the term beyond a reasonable doubt. And once you get to this high bar of beyond a reasonable doubt, there's nothing, then it sets an unfair impediment. That's the kind of impediment that Kuhl talks about. That's the kind of impediment that creates a due process violation under both the 14th Amendment and I believe Article 12, and has the effect, according to Kuhl, of lowering the burden of proof. If I have time, there's another matter that I'd like to address, which has to do with a different, one of the other charges, which is the assault with intent to murder charge. I say in the brief that the judge did not instruct correctly on that because although she does instruct on the effects of sudden combat and heat of passion, this is referring to the individual who, the way all of this begins is Hinds has just run back from the court where he's lost his request to keep his relatives out of the house where he and his mother live. He comes back, he's out in his car, he sees that three of these relatives are outside, he takes a gun from his car, brings it inside the house. He's inside the house, his mother is inside the house, who's frail herself, he's frail. He's had terrible relationships with his older brother. His sister, who he thinks of as allied with his older brother, pushes in the door, it falls down. The defendant's evidence is, which is what's appropriate here for the instruction on sudden combat, heat of passion, the defendant's evidence is that she pushes open the door, he falls down, she comes in, she starts to swear and curse at his mother, who's now turning white, and he's very worried about her, and that's when everything begins.
Yeah, but maybe I didn't understand something, but how are you harmed by the judge's instruction? Didn't the judge's instruction imply that she had already made the legal ruling that there was evidence of sudden combat or confrontation, and then she gave the proper instruction?
Oh, I haven't gotten to the, I'm not complaining that she did everything right except one thing on this part. I understand the rule to be, the law to be in the Commonwealth, that once there is evidence of sudden combat, heat of passion, which, as you point out, the judge found was the case here. Once there is such evidence, the government now has the burden of proof to prove the lack of mitigation beyond a reasonable doubt. Again, now we get back to the beyond a reasonable doubt. The judge does state that the government has the burden of proving the lack of mitigation. She's correct. But by what standard does the Commonwealth have to prove that? The jury's entitled to an instruction on that. And the judge does not give that part of the instruction.
Well, isn't it linked up with the general instruction on reasonable doubt?
I think not. I have just
perhaps not explicitly, but at least conceptually.
Well,
the
it is.
Juror would say, okay, she didn't say how the Commonwealth is supposed to prove lack of mitigation, but she told us the Commonwealth has the burden of proof on everything beyond a reasonable doubt.
No, Judge, that's not what the judge said. The judge said she has the burden of proof on all the elements beyond a reasonable doubt. That's what the judge said. And now we're getting around to mitigation, and she talks about what the elements are.
And your argument is that lack of mitigation is not an element.
It's a defense.
Yes.
It's a defense.
Yes.
Yeah.
Well, I could debate that too, but anyway.
I have a more minor issue to mention in the Commonwealth's brief. They point out that they had first made this request to the trial judge to give this controversial instruction, which is not, in the case it came from, controversial at all, because only the Commonwealth's witness had testified in that earlier case. But, and they say on page 30 of their brief that they had submitted this instruction in writing prior to the judge giving the instruction. The defendant didn't object. And they cite to where that appears in the appendix, in the supplemental appendix. And if you read what's in the supplemental appendix, it is not the same instruction that the trial judge actually gave, because the instruction that the Commonwealth asked for does not have these words in it, beyond a reasonable doubt, which the trial judge added during the instructions.
Now you're talking about the first instruction.
I'm sorry, I should have been
Yeah,
clear.
that's okay.
Yes, I'm talking back about the first instruction, the one having to do with mental impairment and being able to consider mental impairment on premeditation on malice.
Well, it matters, but the lack of beyond or inclusion of beyond a reasonable doubt isn't the key issue. It seems to me the key issue is that the judge, by mistake, said the facts that the Commonwealth has to prove. Just exacerbates it by adding beyond a reasonable doubt.
Well, Justice Cohen, when I first thought about this case, that is what I thought. They're making the Commonwealth do this, and obviously we lose right away. But the more I think about it, I think that we could talk about which is more erroneous
Okay,
here is
yeah.
really what it gets down to. But I think in some ways it's more erroneous to really be talking about beyond a reasonable doubt.
Thank you,
So
Mr.
I see my
Jacobson.
time is up. Thank you. And for the remaining things, I would rely upon what I've prepared in the brief.
Thank you, Mr. Jacobson.
Thank you.
Ms. Lynch?
Good morning. May it please the Court. My name is Adrienne Lynch. I'm an Assistant District Attorney in Middlesex County, and I was the trial prosecutor in this case.
Yeah, can you help us out now, again, going back to our first questions? Do you know where this instruction came from?
Yes, Your Honor. This instruction was originally derived from the model jury instructions for the Superior Court published by MCLE based upon the case of Commonwealth versus Ward.
But in Ward, wasn't that the case where there was only an expert for the Commonwealth?
Yes.
So it made sense there.
Yes, Your Honor. With respect to Ward, in the Ward case, the only expert that testified was for the Commonwealth. The defense in that case had requested that that specific instruction be given. The court declined to give the instruction, and the appeals court, in ruling on this issue, indicated that while the better practice when there is an expert opinion based on assumed facts, that the jury should be instructed that they must find those facts proved, that in this particular case it was not error because the only assumed facts were not disputed facts at trial. Subsequently, the instruction or the issue was addressed by this court in Commonwealth versus Rodriguez in 2002, in which the court indicated that the preferable language is that if it's based on assumed facts, they should be true as opposed to proven.
Have you checked the model instructions on homicide? Is there anything in there about this kind of thing?
My memory, Your Honor, is that there is not. That
It wouldn't be expected because it's really
it didn't
a universal
cover it.
type instruction.
It didn't cover it.
And you say Rodriguez says if it's based on assumed facts, they should be true.
They should, well, the court indicated there that while the language used in Rodriguez was proven, that the preferable language is whether they're true. However, the court did note that that may very well be a distinction without need.
Well, frankly, this thing looks messed up.
Well, the only thing I would say to Your Honors is that in the circumstances of this particular case, in a perfect world, we would have utilized the language in the Rodriguez case, and it wouldn't be a problem. But there is no substantial risk of a miscarriage of justice in the circumstances of this case.
Why?
Based upon the entire charge as a whole, in which during the course of the court's presumption of innocence instruction, the court specifically and explicitly stated at page 74 in Volume 7 that nobody charged with a crime has to prove anything. It is always the Commonwealth that must prove each element of a particular crime beyond a reasonable doubt. That was explicitly stated in the presumption of innocence. Additionally,
That's the problem. That sort of exacerbates the problem because the instruction was that the Commonwealth, you can't consider the facts unless the Commonwealth has proven them beyond a reasonable doubt, consistent with the presumption of innocence instruction.
well, I would have to disagree in the facts of this particular case. The expert testimony, if you really look at it, was not the major focus of the arguments of counsel, nor was it the centerpiece of the defense's case or the prosecution's case on the mental state aspect of the case. Specifically, during the course of Dr. Udewitz's testimony, he was asked one hypothetical by the defense attorney, which was a 13-page hypothetical based upon a summary of the defendant's testimony. However, on cross-examination, Dr. Udewitz was asked a series of hypothetical questions that were very specifically directed to the testimony of eyewitnesses who observed Mr. Hinds on the date of the murder immediately before, during the crime, and immediately after the crime.
Ms. Lynch, so I understand your argument to be, typically if we look at an erroneous jury instruction, we look to the rest of the jury instructions. You're saying take a look at what the evidence was, so if you look at this erroneous instruction in light of the evidence.
Absolutely.
Okay.
And specifically, I would call the Court's attention to a specific question on cross-examination that went right to this very issue, in which Dr. Udewitz himself was asked a question at the record, the trial transcript, volume 5, pages 206 to 207. Dr. Udewitz was asked on cross-examination that if the defendant gave a completely fabricated version of how events happened, that his opinion on mental state relying on those would be totally worthless. And Dr. Udewitz said, I leave that up to the jury. The jury has heard all the facts of this case. They will decide what to take as factual and what to take as not factual. And on the basis of what they take as factual, they will then decide the value of my opinions rather than the hypotheticals. That is, in effect, the crux of the case.
Well, that's right. He gave a nice instruction, but the trouble is he isn't the judge.
But the point of the matter is that ultimately, when Dr. Kelly testified for the Commonwealth, he indicated that whether or not the defendant's version was reliable or not, even if you believed the defendant's version of events, that there was nothing in that version of events, assuming them true hypothetically, that would indicate that the defendant did not have the substantial capacity to form deliberate premeditation or to have the specific intent to kill.
You didn't ask for this instruction, I take it. You asked for something that was more in line with what the case has said. So were you surprised when you heard it?
No, because, and I think that that is an important thing to keep in mind. Mr. Hinds was represented by 3 attorneys, 2 extremely experienced. The case was tried. It was very fact-specific. This is a situation in which the jury had the benefit of having a tape recording of the defendant before a judge of the Cambridge District Court within 1 hour of the homicides. The jury had the benefit of hearing the defendant's 911 phone call recorded, in which the defendant's words to the 911 operator were, "I just killed my brother and sister-in-law and shot my sister." They had the opportunity to hear him talking to the surviving shooting victim on that tape-recorded call, saying, "I wish I could have killed you too," to the sister that lived. The jury had the benefit of seeing a booking tape of the defendant at the Cambridge police station within 2 hours of the homicide. And they also, and perhaps more importantly, had the benefit of seeing the defendant himself testify before the jury to what his mental state was and to be cross-examined about a variety of inconsistencies and basic admissions on his part that he had lied.
Ms. Lynch, can I ask you this, because all of this clearly goes to a substantial likelihood of a miscarriage of justice. Have you read the Kuhl case? I have not. And essentially what Mr. Jacobson seems to be saying, which is the law in other circumstances, is that there are certain errors that you don't reach a substantial likelihood of a miscarriage of justice, because the errors are so fundamental that they almost require a new trial.
Well, with respect to the Kuhl case, I'm not specifically at the moment familiar with the underpinnings of it. However, what I would say is that clearly the defendant is arguing here that the instruction was burden shifting. It is the Commonwealth's position that it was not burden shifting, because no juror listening to the instructions as a whole in the manner in which the case was argued to the jury, which was also important, it's important to realize that it was only 1/2 a page of the defendant's closing argument that addressed the expert testimony of Dr. Udowitz and Dr. Kelly.
Is it fair to say that this was either his sole defense or a major portion of it, the impairment issue?
Well, the impairment issue, the diminished capacity, was that defense, but it didn't rise or fall on the expert's testimony, because what I would say to the court is the following. When Dr. Kelly testified, he assumed that everything the defendant said was true. He was not deprived of the capacity. He didn't have a mental disease or defect. He didn't have a prior history. He wasn't under the influence of drugs or alcohol.
Yeah,
He was
but then
under an
you got
anxiety.
Udowitz saying the exact opposite.
Well, Dr. Udowitz actually indicated in response to hypotheticals asked on cross-examination that if he assumed hypothetically facts provided by the surviving shooting victim about what the defendant was doing, that showed the capacity to make decisions, understand the circumstances. And when the case was
one
argued,
of those areas, we were talking about areas where, like the Kuhl case appears to say, you don't get too far into the likelihood of a miscarriage analysis because the thing is so bad to begin with. One of those areas is when the defense, it's the defense's main issue, main defense, and the instruction strikes at that. It's like, a mess-up where in a rape case, consent is the only defense, no matter how far-fetched the defense, the consent might look to be.
well, not
And
really.
something is said that messes it up.
Well, I would disagree with that, Your Honor, because in the context of this particular case, the defendant's testimony was more important to the defense than the expert's testimony. The defense wasn't relying on that expert testimony, and quite frankly, in the circumstances
Ms. Lynch,
of this...
excuse me for interrupting you. How can you say that the defense wasn't relying on that expert's testimony? I mean, if you have an impairment, diminished capacity, it's very hard for me to understand how you wouldn't be relying on your expert's testimony,
Well,
one's
I think
experts.
if Your Honor were to look at the closing argument, you would see what the defense was, in effect, urging the jury to look closely at, which was the testimony of the defendant.
Well, presumably I don't know, but just based on what you said, I haven't read the transcript, obviously. One reason might be because you very effectively, I mean, as the prosecutor, put a series of hypotheticals based on an alternative version of the facts. That's not always present in a case like this. And so one of the things that the lawyer for the defendant must have felt he or she had to do was to persuade the jury that his version of the facts was the more likely version.
Well, the Commonwealth's argument in closing was, even if you believed everything that the defendant said, he still had the substantial capacity. And that was the manner in which the case was tried on. No matter that they called Dr. Udowitz, you have to look at the overwhelming nature of the evidence in this case.
In that regard, in answer to the Chief Justice's question, you indicated you weren't familiar with the Kuhl case, but I wonder, in the Labriola case, the case says that when an error of magnitude occurs, such as here, I'm adding such as here, discussion of the level of review, i.e. harmless error, substantial risk, or substantial likelihood, is unnecessary. So that case would indicate that you don't go and consider the strength of the evidence.
Well, what I would say to the court is the following. In looking at cases in which burden-shifting language or misstatements are made in a charge in a single reference, and I would call the court's attention to cases cited in the Commonwealth's briefs, specifically the Murphy case, which was a 2004 case, in which the judge stated, if you believe the defendant's alibi, then the Commonwealth hasn't made its burden of proof. The defendant claimed it was a burden-shifting instruction, and the court said that the instruction considered as a whole did not shift the burden of proof, although it varied from the recommended practice. Similarly, in the case of Commonwealth versus Brousseau, a 1996 case, there was an immunized witness, and the court did not give the Champa instruction to view skeptically an immunized witness's testimony. And they said that in that particular case, that the general credibility instructions were sufficient in light of the closing arguments of counsel, which directly made it clear to the jury that that was their decision to determine the credibility of the witnesses. And much as it was in this particular case, Dr. Kelly assumed as true the defendant's version of how the events went. And he indicated that nevertheless, even assuming those facts to be true, the defendant still had the capacity to deliberately premeditate his acts and
But that's not the test, what Dr. Kelly did. The test is, did this affect the jury's acceptance or non-acceptance of Dr. Udowitz's testimony?
Well, it wouldn't, because if the prosecutor asks the defense expert hypothetical questions based on the evidence that the Commonwealth introduces, the jury listening to that case understood that the Commonwealth had the burden of proving mental state, that it was repeated numerous times during the charge that the jury was required to consider all credible evidence of the defendant's mental impairment when they considered issues of deliberate premeditation, when they considered issues of specific intent to kill, when they considered issues of the defendant's knowledge of the circumstances. The jury
Wouldn't
was...
that mean,
But couldn't consider the expert's testimony unless they concluded that the Commonwealth had proved beyond a reasonable doubt the underlying facts.
I think that that reading is unfair in the sense that it takes a single sentence out of context, in the context of the instructions as a whole.
But the only trouble is it's the only instruction on that point. It isn't like other instructions where they're cured by other parts of the instructions.
I would tend to disagree, Your Honor, because if you look at the entire context of the expert testimony, and in this case, the Commonwealth called a total of 8 expert witnesses, and...
Right, so they prove beyond a reasonable doubt their version of the facts and not the defendant's.
Well, no, because some of those witnesses were asked hypothetical questions based upon facts.
Based upon the Commonwealth version of the facts, which completely destroy the defendant's versions.
But the jury had to believe those facts before they could consider them, the expert's opinion. That is the point.
Right, but they were told that they couldn't believe an expert opinion unless they found that the Commonwealth had proven the facts underlying the hypothetical beyond a reasonable doubt.
Well, you focus on that one issue. However, Dr. Udowitz's testimony, in large measure, was also asked specific questions that had nothing to do with hypotheticals. He was asked about anxiety attacks. He was asked about whether or not the defendant, in his opinion, had anxiety attacks. He was asked about records that he reviewed, documents that he reviewed, and it was only that one 13-page hypothetical based upon the defendant's testimony.
I can't believe anybody gave a 13-page hypothetical.
that's a fairly long hypothetical.
It was a very long hypothetical.
See, we can't approach this, on the basis of, well, if we read the transcript, is this guy really guilty? He probably is. We have to approach it from the point of view as, could this have made any difference in the jury accepting or not accepting his defense?
Well, I think the standard is whether there's a substantial likelihood of a miscarriage of justice in the circumstances of the charge as a whole, in the context in which the case was tried. I did want to point out to the court that in the supplemental record appendix at page 5, the Commonwealth supplemental record appendix, it is noted that the tape-recorded jury instructions were marked as U for identification in the case. And
No, I understand that they are marked. I just wondered whether you happen to know whether they are still there.
Oh, I would believe that they would still be in the custody of the clerk's office
Okay,
as
fine.
all exhibits.
Would they help us very much, though? I mean, we got a transcript of what was said.
Correct.
So what difference would it make?
I was just responding to the court's question about
Other than the
whether-
point that the jury might have listened to them on and heard this instruction repeated
but
and
with,
repeated.
But with regard to this, the jury was absolutely clear that the Commonwealth had the burden of proving beyond a reasonable doubt that the defendant had the capacity to form specific intent and deliberate premeditation. They were reminded of it numerous times. They were also reminded in the presumption of innocence that somebody charged with a crime never has to explain anything to anyone. They understood that the Commonwealth had to prove facts relied upon by its expert. And I would suggest that a reading of the instructions is just as easily made that the Commonwealth's experts witness facts had to be proved beyond a reasonable doubt, but because it was mentioned that the Commonwealth had to prove them beyond a reasonable doubt, it pointed out that the defense had no burden to prove anything. In the circumstances of this case, I would suggest to the court rely on the Commonwealth's brief regarding the instructions pursuant to Nardone and Johnson. In this case, Judge Hinkle, in fact, did advise the jury or instruct the jury that the Commonwealth had the burden of proving 4 elements beyond a reasonable doubt in the assault with intent to murder indictment, and that the 4th element was the absence of mitigation, defense of another, heat of passion based upon reasonable provocation or upon sudden combat. And in the totality of the record of this case, the Commonwealth would ask the court to decline to grant 33E relief. In the circumstances of this case, the defendant leaving court, not getting what he wanted, armed himself with a gun, shot his sister in the head, seriously injuring her, and killed 2 unarmed, defenseless people standing on a street corner so that he could eliminate them. Thank you.
Thank you, Ms. Lynch.